All right, well, good afternoon. It looks like we are at that 12 o'clock hour. So I just wanted to welcome you all to course number 3960 from A to Zoom. Today's presentation is brought to you by the Alternative Dispute Resolution section of the Florida Bar. We invite you to visit our website that continues to be updated with the most recent information on all of our upcoming CLEs and any CLEs that we have done in the past that are available. Lastly, we would like to invite you to become one of our members of our section. Our membership fee is $45. That gives you access to discounts on section CLEs, networking opportunities with ADR professionals and other litigators, and many other opportunities. So if you have any questions on that, please don't hesitate to reach out to me. I'm Stephanie Svisco, the admin for the ADR section at the Florida Bar. All of my information is on the ADR website as well as the Florida Bar website. You can also go to the ADR website, which all of that information is actually up on your screen right now. And that will give you some more information about our section. Now, this presentation is 1 hour, and we do ask that your questions be held until the end of the presentation. If you do have a question that is very pressing that you feel needs to be asked immediately, I will be monitoring. If you can just raise your hand and we can have you chime in at an appropriate time. But if not, if you can just if you roll down to the bottom of your screen, you'll see a question and answer box, and you can write your questions in there and we will make sure that we answer those at the end. Our presenter is Jay Hunston, who you see on your screen. And Jay, I'm actually going to go ahead and turn it over to you. So thank you so much for everything. And this is all yours now.
Okay, very good. I'm going to stop your screen sharing and head into my own. Okay, so for those of you whom I don't know, I am Jay Hunston. I've practiced law since 1976. I practiced because I spent 25 years trying to get it right. I was certified as a circuit civil mediator in 1991. I was board certified as a civil trial lawyer from 83 till 2003. But after 25 years of actively trying cases, in 2001, I made the decision to go full-time in dispute resolution. Starting back in 1984, I made the decision to bring computers into my litigation practice. I had probably one of the first litigation department networking systems in Palm Beach County. As I daisy chained, for those of you who are old enough to remember daisy chains, I daisy chained up to 7 Mac workstations together in my litigation department. You did not want to be the person on the end of that daisy chain because it was extremely slow. But that started my interest in trying to be paperless and trying to do more things through computers and sharing documents on computers. The purpose of this seminar is to try to explain to you how I've achieved a paperless mediation practice. Starting in 2001, I have not had a legal assistant. I have nobody to back me up. I have no bookkeeper. Basically, I've been a sole practitioner, full-time dispute resolution since that time. And in order to do that, I discovered early on that I had to get rid of the paper files. My old law firm, back then known as Booth Casey Sicklin, had literally warehouses after warehouses of storage, of bankers' boxes, of files. Many of my old mediation files from 1991 on are in those boxes, I guess. Hopefully they purged them at some point, but those old files with billing information, et cetera, are still there. Right now, I don't need file cabinets. I need a good computer. I need a good backup for my hard drive, and I need good cloud storage, which I have. So in order to maintain a paperless practice, I'm going to run through a couple of things. The first and most important is you have to have an online calendaring system. This eliminates any paper flowing from attorneys who are requesting you to do their mediation to you. It simplifies things. It gives legal assistance a very easy access to your calendar, and it allows those mediations to be scheduled without any problem. I can tell you that what you're looking at is my current calendar. It is proprietary. I'm a member of NADN, National Association of Distinguished Neutrals, and I use their calendar system because it's extremely good. However, there are plenty of calendaring systems out there. You're going to find you could look to Acuity Scheduling, Super SAS, Square Appointments. There are a number of them out there. But I'll tell you, when I started using my own calendar back in 2001 online, there were no calendar apps to speak of. And so it was up to me to come up with my own. I literally went to a free app online for soccer coaches to schedule training sessions and games and get-togethers for youth soccer teams. I was a soccer coach of my children back then. And so I found this app, and I actually modified it to be an online mediation calendar, which allowed people back in 2001 to get into my calendar and request dates. The one thing that you do not want to do is allow people to book directly onto your calendar. Whatever calendar system you devise, whether you get it off the shelf or whether you have an IT person develop it for you, you want to make sure that they request dates. And after they request a date, and you can see this calendar is on the front page of my website. So the first thing you see on my website is a small picture of me, but a big picture of my calendar. It's interactive. You hover over the date. If it shows that it's open, you click on it. And what it does is it requests that date. It gives you this, this view, and you can see that it contains all the necessary information that I need and that the person needs. You put in the requester's name, usually the legal assistant, what firm they're with, what attorney they're requesting it for. I have it selecting morning, afternoon, or all day. Location for mediation is a pull-down menu that is, in my case, 15th circuits, 19th circuit, 20th, 17th, 11th, AAA, because I do AAA mediations, pre-suit mediations, and I've added a Zoom mediation to it so that it tells me when I get the request where the location of the mediation is going to be. The case information is down at the bottom. Once this is filled out, the good news with the NADN calendar system, and if you're devising your own, you should make sure that it retains the information of the requester so that he or she doesn't have to fill it back out the next time they come. It automatically recognizes their email and it pulls up their information. All they have to do is fill in the case name and submit the request with the date. Okay. This is what immediately goes out. It's an automatically generated reply. It tells the requester that their request has been received. It tells them the date. It tells location. Again, it could be 15th. It could be Zoom. It could be 19th. It has the reference to the case number. Here I've used Smith v. Jones. And it promises a response. So the one thing you want to do is timely respond. Once this comes to you and you will receive an email saying that this date has been requested, I immediately send out this reply where I tell them it's penciled in pending receipt of a copy of the notice of mediation. And then I'll send my engagement letters. I oftentimes frequently get requests, are you going to prepare the notice? The answer that I always have is no. Those of you who know me know that I've reviewed the rules for many years and I see no rule that permits a mediator to jump into a case and serve a pleading that's binding on anybody. A mediator is not counsel of record for a party, not a party to the case. And unless there's a specific court order naming the mediator and saying the mediator has authority to set the time, date, location of mediation, the mediator's notice is meaningless. If a party doesn't show up and somebody later on seeks to impose sanctions, the chances are that that party will successfully argue, I think it's problematic, successfully argue that they were never properly noticed of the mediation in the first place. The other reason is because, again, I try to stay away from paper. I don't want to be filing things in the court file. I want the requesting party to send me the notice. It contains everything I need. It contains the full case number, the case style, all of the attorneys who are serving currently in the case. If you've looked at the e-portal for the clerk's websites, you'll see that oftentimes there are 20, 30 different attorneys listed in a case on the e-service portal, but many of them aren't active in the case anymore. So I'm looking for the person who has the knowledge, the assistant who knows the case, to send me a notice in proper form which contains the necessary information for me to send my engagement letter. It's at this point when I receive this notice that I'm going to open my folder. My folder is not brown. It doesn't have two clasps at the top of it. My folder is in my computer. The folder has its case name. I keep track of everything by case name, not by the attorneys, even though later on in the case management system, I'll talk about how to keep track of your cases. But the folder, it starts with the notice of mediation. That's the first thing it goes in. I copy the PDF file into it, and that starts my process. The next thing is my engagement letter. This is my standard engagement letter. For many years doing webinars and seminars and throughout Palm Beach and Martin County. I always tell people that my forms, I don't worry about sharing them. Each of these PowerPoint slides, which contains a form, you'll be able to receive a copy of it at the end of the webinar and in PDF versions, and feel free to use any of the language that you like. I've circulated my letters amongst so many people for the past 30 years that I'm sure that many of them are coming back to other people in other forms from other mediators. But one of the important things in this is that I take all the information over in the blanks under January 1, 2020. That comes from the notice of mediation. Those are the attorneys who are involved in the case. I get the case name information, etc., from the notice of mediation, and this standard letter goes out. These are my old hourly rates, so don't quote me on those. They've gone up since that time, but it explains my billing structure. I don't require people to sign formal engagement agreements with me as a mediator. I confirm to the attorneys all the terms of my employment in this engagement letter. I explain where I do and don't have travel charges. I do explain how we're going to split the mediation fee as I understand it. And I point out that if I'm not paid at the time of the mediation, that I look to the attorneys to remit the balances due under the mediation. Sometimes I get some feedback, some kickback on that, but not often. Usually attorneys know their clients, and they know if they're slow pays, they tell them bring a check with them. And if they aren't, they prepare to stand behind the bill when it comes. This includes a disclaimer. Remember I said, feel free to use my forms. I'm trying to show you with my arrow. This paragraph is new in my engagement letter. Chris Hopkins, a local attorney here in Palm Beach County, gave a seminar on ESI and electronic security. And he uses a modified form of this paragraph in his engagement agreements as an attorney. And as I do, he said, here it is, it's on the slide, feel free to pick it out and use whatever part of it you want to in your own. I lifted much of his language and modified it for mediation for me. And this basically tells people that emails are like postcards, that we all know that. They're not secure. They just aren't. I have an encrypted email service that I subscribe to through Identilict. So I can communicate with fully encrypted emails with parties and with attorneys, but they have to request it. And I point out that if there is a higher degree of security required, they need to tell me in writing in advance. This is the way I stay away from papers. I remember the days starting in mediation, I would receive literally 6 or 7 3-ring binders, 3 inches thick, with materials, copies of every pleading ever made in the case, ever filed in the case, copies of it, full sets of interrogatories with answers, copies of every document that was produced in discovery. All that paper would come to me, and those were the days that you sort of regret. Today, I can tell you that I haven't had a physical delivery of a hard copy mediation summary or mediation package for probably a year. And I did have one request in the last year, and I quickly told the assistant, because I only operate out of a PO box, and so people can't FedEx to it. So they call or email and say, where's your physical address for me to deliver these thousands of pages of documents? And I quickly tell them, you don't need a physical address. All you have to do is use either Dropbox, ShareFile. There's plenty of apps out there, and just get them to me by email or PDF. If they're voluminous, put them in a ShareFile. I assure people that whatever I receive by email or PDF, at least a day prior to the mediation, I will review. I've reached the point where I review everything the evening or night before. because if a mediation cancels and I've reviewed all the documents 2 weeks before or 1 week before, I've used a lot of brain synapses that at my age I don't need to use up anymore. And the case settles or cancels, and the next thing I know, I've got all that information that I really don't need because I'm not going to do the mediation. So I accumulate the emails and PDFs, I put them in the folder, and then the day before I'll go to that folder, open it up, and I'll go through and review what I've received. Now, I showed you my standard form engagement letter for a simple mediation. I do have a multi-party engagement letter, which talks to construction defects cases where I might have 15 or more parties. I do in that standard letter request that the parties submit by email and PDF their mediation summaries at least 1 week prior to the mediation. In those cases, and you know which ones they are, you can always tell by the number of attorneys involved and the case style. In those instances, I go through a week before and review everything that's been submitted, because I'm probably in those cases going to have to do some pre-mediation telephone conferences or email exchanges with the attorneys involved if there are questions that come up through their written submittals, their PDF submittals. So in those larger cases, I do request at least 1 week in advance that I receive those documents. Okay, so like I say, for a year, and before that for quite a while, but I have received few, if any, hard copy mediation summaries. This is my newest engagement letter. It's the same as the one I just showed you. This isn't a multi-party one. It does have my current hourly rate, so you can quote those. But the Zoom conferencing procedures, obviously COVID-19 in a paperless society has made us even more paperless. We don't drive to mediations anymore. We don't have to carry files with us to mediations anymore. We do most everything via Zoom. And so I've added this provision, and I made it up out of whole cloth. But again, you're welcome to use it if you think it sees fit. What I tell people in my engagement letter is 3 days before the mediation, I need email addresses for all participants, because I'm going to conduct the mediation via Zoom. I'm the one that has to do the Zoom invitations, and I'm going to use those email addresses that they provide. So in my engagement letter, I say that, but I can tell you that since COVID-19, my calendar has become a series of reminders, because what I do is I put in a reminder 3 business days prior to each mediation that I have, and it reminds me to send an email, which is a standard form cut and paste email that I have. That email goes out to all of the attorneys who are in that mediation coming up for 3 business days later, and reminds them, I need your email addresses for your participants and for you. I don't ever trust that attorneys are going to remember it. Sometimes they do, most times they don't. So I send that second request by email and say, don't forget to send them to me. I do point out in here that a lot of times I'll have a request for the Zoom link so that people can put it in the notice of mediation. Notices of mediation are filed of public record. That means that Zoom link and password are going to be public record. They're going to be in a notice of mediation that somebody filed. I only send out the Zoom invitations the day before for a couple of reasons. Number one, I think it increases security because there's less chance that somebody's going to circulate that email with the link and the password to other parties that really don't need to be involved. But the other reason is because it's on the top of the inboxes of all the participants in the Zoom mediation. So it's not buried a week ago in their last emails and they have to scroll through to find it. It's going to give them the current Zoom link on the top of their inbox, and it makes it easier for them to locate it. Always provide a contact phone, which is your cell phone normally, because people will have some troubles with Zoom connecting. You want them to be able to get a hold of you. Emails are also, you could put in an email address. Okay, so now we get down to how do you stay away from a case management system that relies upon paper. I've used 2 in my practice, and that goes clear back to 1991, because I started a case management system for mediation in 1991. I used Abacus Law, and the reason I did is because my prior law firm was a PC-based law firm. I've always been Mac-based, and the problem with Abacus Law is it doesn't have a Mac-based version. You may have a case management system that you like. You may be just starting out to try to go paperless and maybe looking for them. I've got a couple of suggestions at the bottom, but the most important thing in this day and age is, in my opinion, is to have a cloud-based system and have it compatible with both PCs and Macs so that you can use the platform of your own choosing, the operating system. What I've done, what I had to do was I had to archive all of my Abacus Law information. It tracked every attorney, it tracked every party, it tracked every adjuster, it tracked every case number. It had every bit of information that comes from the notice of mediation and from actually conducting the mediation. It was all there in my Abacus Law database. I had to archive that just because Abacus Law became too cumbersome for me in terms of its updating of its licenses every year. And it required me to keep either a Parallels program running on my Mac so that I could run a Microsoft operating system so that I could open Abacus Law. I finally made the decision that it was just getting to be way too much effort, quite honestly. I searched, I looked at Clio, I looked at any number of other case management systems, most of which are designed for litigation, not for mediation. I ended up choosing MyCase. The reason is it's got a monthly fee. I can terminate it at any time. I archive the information. It's my information, even though it's cloud-based. It's Mac compatible, but more importantly, it allows me to index my cases by quote client. Well, we know in mediation that the participants in the mediation are really the active participants that we are attempting to help, but the people who retain us, the attorneys, are in essence the client, not officially as a lawyer, but that's what I base my system on. I don't have a system that's case-based. I don't want a system that's case-based. I've had that before in Abacus Law. This system, basically the requesting attorney becomes the client. It's not useful for billing. I still do billing separately because it wants to bill everything to that client. But the reason I use it is because it gives me that focal point to check in with the attorney who's scheduled. That's going to be the first contact, and all the other information is in the contacts in the actual case management system, in my case. So I input each of the attorney's information. Once it's in, I don't have to re-input it, obviously, because my computer does my thinking for me. That's the purpose of not having pieces of paper. My computer does my thinking. So when I have another attorney, another case that involves Joe Smith as the attorney, once I plug in the last name Smith, well, I get a whole bunch of them if I did that. But once I plug in the last name of the attorney, it gives me the choice is which attorney in your database you want to use. You click on it, it pulls all that information in, and you have a running ability to report, especially for conflict checks when you do arbitrations as well as mediations. Conflict checks, because with the AAA, American Arbitration Association, conflict checks are important, and you have to be able to disclose prior dealings with both attorneys and the parties. So you want the conflict check capability in your case management system. You want billing and reporting capabilities so that it keeps track of your ARs. I don't use it for my invoices. I have a standard form invoice that I just fill out at the end of the mediation and email to parties. You'll see that later. But when I get back, it inputs how many hours, it knows my hourly rate, and it automatically puts in, okay, on this date, you sent this invoice, and 30 days later, it throws it into an aged AR, which will give me a report whenever I request it, and I can send out email reminders to anybody who's over 30 days past due. Keep in mind your licensing issues, because when you purchase a case management system, some of them have, like my case, where it's just you pay monthly and it's yours as long as you pay. Some have a licensing fee that you have to continually update. Okay. And the neat thing is, here I am doing a paperless mediation webinar, but because we're setting it up through a screen share on my computer, I can't use my PowerPoint with the presenter notes in it, because you would be seeing all the presenter notes that are reminding me about the high points to hit, and you would have a smaller screen on the slide. So what I had to do, not being paperless for webinars, I had to print up my notes and put them on the side of my desk so that I could look at them to make sure I cover everything that I want to get covered in this webinar. Okay, I've jumped ahead, case management system. This is the last remaining piece of paper that I actually generate and take with me to a mediation if it's in person. And the reason is because although I could have people put their names on an iPad, I take the time to visit with people in the joint session, to talk, to basically discuss what's going on in the weather, whatever. And I pass my yellow pad, my standard lawyer yellow pad around the room and ask people to print their name and who they represent into that pad. If I pass my iPad, number one, it may come back with a different app functioning on it than it had when I sent it around. And secondly, I've discovered that a lot of people, especially party participants, are not comfortable trying to write on an iPad, or whether you use a Microsoft product or whatever product you use, but on an iPad, because if they put the heel of their hand on it, it moves the screen and they can't get their printing to work. So in-person mediations, I send around my legal pad, ask people to print their names in. This is my roster, so I know who's covered by confidentiality and privilege. When I get back to the office after the mediation, this is scanned into my folder for that mediation. Sometimes if there are multiple parties, the people will ask, could you provide me a copy of the roster? But I scan it and then I shred the document. So even though it starts out as a piece of paper, it doesn't end up as a piece of paper. It ends up as bits of paper in my shredder. All right, now that we have Zoom mediations going so much, it's become a lot easier, because when I get that list of participants, it will include names and email addresses. So I know who's going to participate. If I have a mediation where an attorney says, well, I'm going to send me the link and I will send it to my adjuster, or I will send it to my party representative who's going to attend, then at the beginning of the Zoom session, as you all should know, you get a gallery view, which I use. It shows the names of the people attending, but I always go around, just as I do at an in-person mediation, ask people to introduce themselves, and then I make my own roster on my iPad and make sure that I list everybody who's present, because that part of my notes in my iPad I'm going to save for the file, because I do want to know who was present at the mediation. That's something that I don't destroy at the end of a mediation, because it's important to know who was covered by the privilege. So when I get down to the question of who I actually represent, how I actually take these notes, I'm going to try to have enough time, and I'm looking at my watch, I should be able to demonstrate the Note Taker HD app that I use. I'm aware that there are plenty of apps out there, GoodNotes, Notability, Nebo. There's a bunch of note-taking apps out there. I found Note Taker HD years ago, and I've used it successfully. I find it to be an extremely helpful note-taking app, and I always joke with people in my in-person mediations when they see me taking notes. Invariably, one, if not all, attorneys will say, "What's that app that you're using, Jay?" And I always tell them what it is, and I've always thought I should get a commission for all of the people who've gone out and purchased Note Taker HD after watching me use it. But at $4.99 a piece, I don't think the commissions would really do much towards buying lunch. In any event, I take all my notes on the iPad. That's the only thing I'm going to do. If, for instance, the mediation continues, it goes to a second or third day, or it's going to be adjourned and then come back later, I retain the notes. If the mediation concludes successfully or unsuccessfully, although I will tell you, if it doesn't reach an agreement, I will retain the notes for a period of time, because I don't know how many times a mediation has impassed, and then 4 weeks, 5 weeks later, you get a call, Jay, I remember that mediation you did, we'd like to get back together. And so even though it does impasse, I normally will not go through and purge my notes out of my iPad for a period of time. If I'm on the service list, I'm going to see if the case proceeds to trial, or if it ultimately settles or whatever, and I can then go ahead and delete. The reason I like using the iPad is because, unlike computers and laptops, if you take notes there, you have a hard drive. Your hard drive, we all know, is discoverable. Your hard drive is going to retain a lot of metadata that's going to be recoverable later on. An iPad doesn't have a hard drive. An iPad, I don't keep my notes up in the cloud, so the iPad is basically in its own flash drive. And when you delete, if you've ever done that on an iPad, once you delete notes that you've taken, you're not going to go back and find them. The flash drive is going to get rid of them, which means that once I hit delete on my Note-Taker HD app and delete that set of notes, I know that they're gone. One of the reasons that I've switched, but I did it many years ago, to discarding or shredding or getting rid of notes is because early on in the early 90s, I got my first and only subpoena to appear in front of then Judge Hoy because I'd done a mediation 2 years before, and the parties had a question. They waived confidentiality. They wanted to know if I had anything in my notes reflecting the issue that they were discussing, because they know that I'm a prolific note taker. And sure enough, I still had my notes 2 years later. And so when I got the subpoena, the question wasn't present recollection refreshed, because I can guarantee I didn't remember a thing about that mediation 2 years later. But they brought them in as past recollection recorded, so a copy of my notes went in when Judge Hoy said everybody waived and I'm ordering you to produce them. And so I got my back then $10 witness fee check and left, and after spending 45 minutes out in the hallway of the courtroom. So after that point, I destroy, I shred, and I delete my notes once I know that the mediation is not going to come back after an adjournment or after an impasse for further review by me. iAnnotate 4 is an app which I have found to be worth far more than its cost of $10. There are plenty others. Adobe now has come out with a lot of PDF annotation type apps, and there are plenty of them out there, but iAnnotate 4 I like because it works out of my Dropbox. Anything that's in my Dropbox, which is where I keep my information sent for each mediation, I can literally pull that document out, and if there's a contract, for instance, maybe there's a 30-page construction contract, but we all know that only 4 or 5 paragraphs or clauses are really going to be of importance in the mediation. I can cut those out. I can copy them and paste them in, and I can use iAnnotate because I just open that PDF in iAnnotate. It allows me to fully annotate. It allows me to cut, paste, highlight, circle, redline with my Apple Pencil. I mean, I can do all that with impunity. It's just like having it beside me in paper. And I make notes to myself, important clauses, but more importantly, I can then take that and cut out a piece of the document that's really going to be critical, and I can then put it into Note-Taker HD, so that literally on my notepad that I'm going to be taking my notes on, I have critical clauses in text version already in there. I can then highlight, I can write, I can annotate those in my notes. I can move it around. I can put it on a second page if I don't like where it is in my notes in the first instance. And so using iAnnotate to convert the PDFs into manageable form, and then cutting and pasting into Note-Taker HD, it allows me to have just my notes open during a mediation and not have to keep referring back to the PDF files that were previously provided to me for information. The calculator app that you see up there is an easy one. It's basic, it's free. It doesn't have pop-up ads, which are ridiculous, but I only keep it in my ADR resources folder because we all know that sometimes we have to do a quick calculation, and it's an easy one to open up and to use. Okay. So we've conducted the mediation. We now have our notes on Note-Taker HD. We've concluded the mediation, and now we have a mediation settlement agreement. Again, I don't carry paper. This document is in my standard forms. It's a very simplistic mediation settlement agreement. Fill in the blanks for somebody pays somebody money, or if it's a more complex case which has people exchanging properties or doing something else, then you just take out paragraph 2 and put in whatever the provisions are, the bullet point provisions that you need. I've found that in my experience as a mediator, I'm being paid to be a neutral, and this form, in my opinion, is a neutral form. It gets the point across. says what the parties mean, and in most instances, and it's because it's neutral, from my perspective, it's better than concluding a mediation where the parties have all not necessarily shaken hands, especially if they're on a Zoom mediation, but they've agreed on what the deal is. And then the wordsmithing starts. And then for the next 4 hours, one attorney may prepare a draft of a mediation settlement agreement, which is so one-sided that the other side has to spend an hour reviewing it, changing it, putting in their one-sided terms. And by the time you're done, and we've all had this happen, the deal falls apart because of the wordsmithing of the deal. And it wasn't that the parties didn't have an agreement. They did have an agreement. It was a matter of getting it into writing. If you have a complex agreement, I have a provision I put in that says the parties are going to execute a more formal document, basically effectuating the terms and conditions of this mediation settlement agreement. That allows the attorneys after the mediation to go forth and come up with, in one case we had I think it ended up being probably a 10-page release document in a construction case. So there are those cases where you can't necessarily have the final document done, but I find if I bring a neutral term sheet in with me, that the attorneys are, especially the ones that have known me for 30 years, are comfortable using that as the formalization of the agreement so that we have a binding agreement when the term mediation terminates. You'll notice here that I have what I call my standard language, that the settlement agreement may be executed by original electronic or facsimile signatures and in multiple counterparts. Especially in this day and age of Zoom, when I reach an agreement in a Zoom mediation, I'll start with in-person. In the old days, and when we get back to in-person mediations, at the conclusion of the mediation, I've got this form. I carry my laptop with me to in-person mediations because what I'll do is I'll fill in the blanks and then I'll email it to the attorneys. The attorneys generally will have either a laptop or an iPad or something with them. They can review it. I send it to them in Word format so that we can track changes if need be. And they can work on their versions in their own separate rooms and come up with whatever revisions or additions they want to put in. Then we get together and we basically bring all those comments into one document, agree upon a final form. I save that final form in my laptop and use that to basically either print, if we're sitting in a attorney's office who wants to print it out and have physical signatures, we can do that. But more often, I end up sending it by DocuSign. And if everybody has their email address there, we sign it via DocuSign. Or I started towards the end to just take out my iPad, because even the party participants can usually handle an Apple Pencil and an iPad to put their signature, their mark, over their signature on the form down here where their name would go. Oops, let me go back. I've got to shift out of here because I put this right in front of my controls. Down here where their name would go, most people are comfortable with signing on an iPad. And then what you do is, because again, I've got it in iAnnotate 4 when I do that so that it can be marked up and signed, then I flatten it, save it as a flattened PDF so it can't be changed. And then I email the fully signed document around to the attorneys. So that's a matter of paperless signatures, because when you finish your mediation, you want those signatures. And now you can either do it by printing, getting a hard copy and then scanning. You can do it via DocuSign. You can do it directly on your iPad using an annotation app such as iAnnotate 4. All right, now we get down to the report of mediator. This is not necessarily your last step, but you're going to be filing your report. Obviously, the good news is we don't have to worry about huge certificates of service anymore. We can say that it's going to everybody who's in the case that's on the e-portal. I have now modified this form. You'll see here that they were present either in person, by audio, video, communication technology, or through counsel. This phrase is in the works in amendments to the rules of judicial administration, that because of COVID-19, we're all trying to amend rules and come up with ways to codify what we're doing remotely so that it's, number one, enforceable, but number two, could be used in the future moving forward after COVID-19. This phrase, audio video communication technology, right now is the language they're using in the definitional rules of the judicial administration to cover Zoom technology, WebEx, any of the other platforms. So I lifted that, and I now have that either they were in person or via, and also the definition is broad enough to include telephone conferences if literally somebody just called in. And then obviously sometimes they're through counsel if the parties have agreed. So this is the last document that I generate to file. And keep in mind, I didn't file the notice, so this will be my first filing in the case. But the last thing, obviously, then is your billing. With the billing, I include this email, and again, my billing is just a PDF. It's just a Word document that I fill in the blanks, convert it to a PDF. I send it with this email, but I also include my firm's W-9, another PDF document. And I discovered early on that if you send your bill but not a W-9, 2 or 3 weeks later, you will get a call from a legal assistant saying, hey, I just received your invoice and I can't process it until you send me a W-9. So probably those of you who are actively doing mediation already do this, but I automatically send a W-9. Firms that I deal with frequently probably have more PDF files of my W-9 than they need, but it doesn't matter, I still send them. So that way you don't have an AR problem, hopefully, and you don't have a lot of those aged AR reports coming up on your case management system saying, hey, it's been more than 30 days and you haven't been paid on this file. Okay. And this is a copy of the bill. Keep in mind, I do this as a word processing document just because the case management system I have, my case, wants to bill anybody you named as a client, but I explained to you before, I only have one client in that system. And my bills are always split between various parties, and I have to figure out how to split them, who's going to pay what share, and what the total amount due per party is. So I still do it as a word processing document, but again, it's in my folder on my computer. Once mediation is concluded, I mean paid in full, everything is done, that folder goes into my archive files. I don't keep that in Dropbox. I don't keep it in the cloud. I put it into my archives, and then in my backups, because I regularly back up my hard disk on my computer. I've got all of those archive files, and again, I can go back and search and find anything that, anybody's name, anything that I've done, any case that I've been involved with, and it's not a problem. Okay, so at this point, because I'm trying to save time for questions, because last count I saw, we had over 81 participants. So I'm trying to save time for questions, but I think it helps to see the, okay. This is the way my note-taker HD looks. You can pick various backgrounds. I pick a legal pad background because I'm comfortable with it. And I even took it and drew my little line down the right-hand side like I used to do as a trial lawyer, so I could put my notes out there and other notes inside. The first thing that you're going to want to do, obviously, is you want to know what this set of notes is for. And again, I think I decided that early on in law school, I decided it's a good thing my name wasn't Smith or Jones, because every time one of my instructors, professors, would give us a hypothetical case in a law school exam, it was always Smith v. Jones. And I think I probably would have felt bad if my last name was Smith or Jones. So you give it a title. So now you're editing not just an unnamed document, you're editing Smith v. Jones. These are going to be your notes. You'll see up here a zoom. If I click on zoom, it gives me this little square. I can move this square anywhere. Wherever I put this square, if you look at the bottom, you'll see an enlarged view of that square. So if I want to take notes on who's present, all I'm doing literally is, it's at the very bottom of my iPad, I'm writing in the bottom, and it's putting it up in the place that I designated for it with the block. So I can say up here, all right, I want to make sure on my notes, I also say this is Smith v. Jones. And I want to say that we're doing this one on the 16th of July at 12 p.m. Here you can take your notes as you're going through and they're explaining to you. The plaintiff says this is a simple real estate contract deposit dispute. And you can see if you don't see this shaded area. If I keep writing over here, eventually I'll end up into the shaded area and it will automatically move and write it where I really want it to be. So if I say it's a $50,000 dispute, I write in the shaded area and it puts it over on the right. So it's keeping track of all my notes up here. Remember I told you I can cut and paste. You go up to the tools and you can say under mode that you want to insert type text. And what that does is it gives you the ability to create a block. And over here, you would type. I don't have it set up to type. I can type. And it types it down in the types text. What I do is I cut and paste those critical contract documents, those provisions. You cut and paste, and then up here, instead of typing, you basically say, okay, I want to paste. And you'll see that the paste opportunity comes up. Here it wanted to cut and copy. But if I just go here, it'll allow me to paste something I've taken from another document and put it in here. It will automatically put it into this block. Okay, and then again, obviously this block can be moved anywhere. You don't have to leave it in one place. And then you write your notes around it. All right, when you're done, at the conclusion, you go up to the done at the top. I'm not going to hit it because it brings you back to the screen with all of your notes. And I have some active mediation notes that are still open from mediations that are ongoing. And so if I click done, you'd be able to see a list of those. I'm not going to do that, but when you click done, it basically saves it into your iPad's flash drive. And then again, like I said, when you're totally done and you know that you don't need these notes anymore, you go into that note taker app and click on that file and you hit delete and it's gone. Okay. All right, and I think, Stephanie, that I allowed enough time. I was talking too fast, so I couldn't get your, I didn't get your little Zoom chat, but hopefully my wrestling papers weren't too distracting, but I apologize.
They were not too bad. I just thought that I would let you know.
Well, I didn't see it till now, so now you know.
No problem. So I believe then that we want to go ahead and open it up to any questions that you may have. So as I said before, there's the question and answer box at the bottom. There's also the ability to raise your hand. If you have any questions, if you would like to go ahead and either type those in or raise your hand. If you raise your hand, I'd be able to allow you to come on and ask the question actually over audio. So I'm going to give everyone just a minute here to type in or raise their hand if they have any questions. Okay. All right, it looks like we do have one question that came in, Jay. The question is, your invoice form contained no detail. Any pushback from participants?
No. I will if I have an instance where, because generally, even though my engagement letter says I charge for prep and for doc review and all that information, generally I don't, just because I find that it's, I just don't do it, and probably should, but I don't. If I have a case that has significant review and prep, all I do is I add an annotation under the total hours spent that just says it includes doc review and prep. And then I give a gross total of time because, and I've never had a pushback on it, never in 30 years. So parties know how much work you're putting in and they know how many hours it took. So no. And I think probably it's also because I don't bill for that extra prep time in the majority of cases. So they know I was there at 9 a.m. and they know we left at 3:30. So that was a 6.5 hour mediation.
Awesome. Thank you. We've had some other questions come in. The next one that we had was, have you found that online mediation is more or less effective or the same?
Okay. I've had that question because we're all doing a lot of Zoom mediations. I'm doing minimum 3, probably 4 or 5 a week. I only do 1 a day, so that pretty much fills the week. So I'm doing a lot of them. And at first I found that it was as effective as in person. As I got into a couple, after I'd gone through 10 or 15, and I had one especially I'm remembering, that pops out in my mind, where it was a complex case. It was a high emotion case. And it was too easy for one party to just throw in the towel and say, you know what, Jay, thank you, but we've gone as far as we can and we're done. And so it's a little less effective in my opinion because they can hit the leave meeting and they can terminate the mediation session without having to actually gather their files, pick up their briefcase, go out in the hallway where you can talk to them and say, are you sure that really there isn't something we can do? So it's too easy to exit. That's the only drawback I see to it. But other than that, I'm finding that it's still overall as effective, 90% effective, if not more than 90% effective.
Okay, great. Thank you. All right. What platforms do you find participants most comfortable with for digital signatures?
Everybody, well, not everybody, but most people now are used to DocuSign because all the realtors started to use it. So
right.
Anybody who's bought and sold a house recently knows DocuSign. And so when I first started to use DocuSign, nobody could figure out where to put their signature. They would put them all over the paper. It would end up in the upper right-hand corner instead of over their signature block. But now DocuSign is probably the easiest. I still have people who want to scan and fax and sign and fax, but that's getting rarer. So I would say DocuSign is probably the most popular platform because it's so easy to use.
Okay, great. Okay, are you running into any problems with, quote, electronically signed signatures on a settlement agreement as opposed to traditional signature?
I have never had that issue come up, and I've been using that electronic signature language in my mediation settlement agreement forever. Because originally it was for fax signatures, because we all know before we got really good at electronic signatures, we would oftentimes fax out the settlement agreement. Somebody would sign, fax it back. We would have multiple signature pages that had 1 or 2 signatures on one or 2 on the other. And the courts were enforcing them. And now with the electronic signatures, especially with DocuSign, but even where you have them sign on the iPad, I have not heard of an instance where a court has said that's not enforceable. Especially where you have the language that says that you intend for electronic signatures and multiple counterparts to be enforceable as an original.
Okay, thank you. Do you do any family law mediation? And have the Zoom mediation techniques worked with family law cases?
Okay. I'm certified in family law, have been since 1998. Originally, I did family law mediations. And then a few years ago, I said, you know what? I'm so busy, I'm not going to do them anymore unless they're just business disputes. So if they involve minor children, I will not do a family law dispute. And most of them do involve minor children. And so I can tell you that I haven't done one in the past 2 years. However, having said that, I can tell you that in Montana, my other jurisdiction where I practice, because of the size of Montana geographically, and mediation out there is very, very popular and successful in the family law area. The Montana Mediation Association is mainly family law, and I'm a member of that, and I talk with them a lot. They find Zoom, they all use Zoom. They find Zoom to be extremely effective, especially because in some of those little towns, little rural areas of Montana. In one town, there might be one attorney. And you can tell that where you have a one attorney city, I'll call it a city, town, it's tough to have a divorce that's contested, because who's going to represent the wife and who's going to represent the husband? So Zoom has allowed attorneys to expand their practice in Montana and represent clients from 400 miles away. So it's very effective out there, and they all swear by it.
Okay, thank you. How do the parties separate during the Zoom mediation? Do you have a meeting first of all the parties?
Okay, briefly, because I promised this wouldn't be a Zoom webinar, but all that happens is when you send your invite, the people are going to arrive. You want to have your own platform to host. And if you're going to seriously consider mediation via Zoom, do not use the basic free version. Pay for the pro version. It's well worth it. It gives you a lot more capability. But what it will do is it will send everybody into a waiting room. And in that waiting room, it's sort of just white space. They're there. They know they're online. But they can't talk to each other, and they can't talk to you. If I've got a period of time where everybody isn't there yet and I don't want to admit everybody into the joint session, I will send a message to the to the waiting room that says, we're still waiting on a couple more people. Don't worry, we'll be getting together in a minute. Once you admit them, you admit them all into a joint session where everybody is there. They can see each other, they can hear each other, they can talk to each other. And then after the joint session is conducted, then you've previously set up breakout rooms for each of the various parties. As the host, the mediator, you assign those people to their breakout rooms. They get sent to the room. Nobody can get into that room except you and the assigned people. And they spend the rest of the caucus time there. You can bring them back into the main session if you need to get them back together for some reason, but they spend the majority of the rest of the session just as they do in a normal mediation in person in their breakout rooms, and you go back and forth and go in one, then go into another, and talk with each of the parties individually.
Great, thank you. Let me see, I'm actually going to go ahead. Let's see, Kathleen had asked, while you're a prolific note taker, I'm not. I would like more information on this program. Kathleen, you will be able to view this program again. So we will be posting the replay of this, and we'll get that out. If you want it directly, you're more than welcome to ask me for it, but it will be on our website here in the next week.
And Stephanie, if I send you just a PDF that has the PowerPoint slides on it, do you have the ability to circulate that to people who request it?
Yes, I can definitely do that. I have everyone's email address that registered for this event. So yes, I can definitely do that. I think that would probably be very helpful.
Okay. I'll send that to you afterwards.
Perfect, thank you. How has virtual mediation affected the mediations you have conducted in terms of the dynamic, good and bad, of in-person sessions?
I think the dynamics stay pretty much the same, because I try not to have people just call in. You can call into a Zoom session, and all that the other people see is a phone icon, and they hear you. I try not to have people just call in, because I do want to see them. And I think if they can see me and I can see them, it's as close as I can get to being there in person. And in case you can't tell, I'm a fairly emotive person when I speak. The only thing you can't see is my hands move all the time, but that's a good thing because I talk with my hands. In person, people can see me talking with my hands, but they can't on my Zoom screen. So I find that the dynamics, you can use Zoom very, very effectively in terms of even where there's emotion involved. I have this, I don't know, I like to not bring people down in a caucus room, and I try to find something light. And invariably, I can usually find something to talk about that's going to bring a smile to faces, and then we can move forward and get something done. And it hasn't really affected it versus in-person versus Zoom.
That's great to hear. Thank you. All right, let me see. Has the quality of the technical equipment for the parties or mediator caused any problems?
Yes. Yes. When people come in with an iPhone, they have limited icons and it's harder to find them. And they're looking at a very small screen. And I apologize, that's my other phone ringing, but it shouldn't be too distracting.
You're fine.
It ends after 4 rings, so it'll go to my voicemail. I actually had it turned to silent, but obviously that part of my technology was lacking. So iPhones are more problematic. iPads, once you get used to it, my wife uses only an iPad. So when I started testing Zoom for complicated mediations months ago, I used her iPad as my guinea pig so that I could be the participant with her iPad and use my laptop for my hosting. And I discovered that some of the icons are in different places. So when you've got participants, you have to be able to say, okay, if you look down in the right-hand bottom corner of your screen, you will see and ask for help in a breakout room, as an example. They always have to find the ask for help, because if you haven't been in their room for a half an hour, they think you went to lunch and they want you to come in their room. Instead of opening the door and going to look for you, they click on the ask for help button. That sends you a private message that says you're wanted in breakout room such and such, and you can then quickly shift in there and find out what the problem is. So I encourage everybody to look at Zoom as a participant on a number of different platforms, devices, so that you can help when people have a problem and say, well, I don't see that icon. Oh, that's because you're on an iPad and it's in the upper side. It's on the top bar, not the bottom. So.
Thank you. Let's see, a couple more questions here. What is your preferred backup software?
It's not a backup software. I use a Western WD, and it's basically this huge mega, I don't know how many terabytes or whatever it has, but it can back up my entire computer, and it runs continuous backup so that I'm not ever in danger, or at least in fear of losing things. So it's, I think, Western. I don't even remember. It's sitting over on the desk, but there are so many of them now that it's a plug and play. You just plug it in and it backs it up. Or if you've got it set for automatic, it's just going to back up to it automatically.
Great. How do you allow the parties to confer privately with their counsel? And I think I think you went over that earlier. Sorry.
That's okay. That's the breakout room.
Yes. Okay. Perfect. How do you handle parties sharing or introducing a large number of documents via Zoom?
Okay, a couple of different ways to do that. And screen sharing, everybody's getting very comfortable with. The PowerPoint that I used here, people can do a screen share just like I did with a PowerPoint and to use that. If they have documents that they want to show, sometimes I'll have them email them to me, and then I'll actually open them up, excuse me, in the caucus rooms, in the breakout rooms, to discuss with the other parties if they don't necessarily want to share them with them. And for an I've got a 5-day arbitration coming up, which is going to be voluminous. There you do need, for the witnesses, hard copy exhibit books that are identical, that they're going to use in their testimony, that they're referring to, but you've got all those documents on your PDF. So it depends on how voluminous you mean.
Okay. Okay. Do you notify the parties or attorneys that the Zoom mediation is not recorded nor archived?
Absolutely. And I do not you set your privacy settings when you're the host. I don't allow private chats. The worst thing in the world, and this comes from Montana, when one mediator did not disable private chats, and it was a family case, and there were some fairly scurrilous chats going on, which torpedoed the mediation. Excuse me. So you set your privacy settings as the host and then never change them. I do not allow recording. because it's a mediation. Now, in this 5-day arbitration that I'm going to be hosting, they want to record it on Zoom, so I'm the one that's in charge of that, just like Stephanie's in charge of recording here, but nobody else can record. So all that's set up in your Zoom privacy settings.
Perfect. Do you announce that you are about to enter the breakout room?
You can't announce you're about to. Some I know send chat. They'll send a text message. I find that I don't really walk in on private caucus meetings where they're saying bad things about me too often. But in person, you knock on the door and then you walk in. Mm-hmm. Zoom still doesn't have that functionality. All of us have been trying to get them to do it. So when you come into a breakout room as the mediator, the first thing that happens is your video pops up. So everybody who's got video sees your smiling face and knows you're there. But the other thing I do is as soon as I go into the breakout room, I announce I'm back. And they all see, oh, Jay's here. We got to stop talking about it.
Perfect. Yeah, it's too bad they don't have that function set up yet.
I'm shocked, but they've been working on security more than anything else.
Yeah, which actually leads us into our next question. Do you have any concerns about the security of Zoom? Says, I had parties express concern about it, so we have used Microsoft Teams.
There was a whole lot of, I consider it, misinformation out there early on with Zoom because it became so prevalent. The current security settings, every mediation you do now, it goes out as a random meeting number with a unique password. And participants cannot get in unless they actually have that link and that password. That's why, if you remember, I said I don't circulate them a week before or have them put into a notice of mediation, because all of a sudden anybody can get in. But the other security is in that waiting area. In the waiting room, I can see, as the host, I can see who's in there. Mm-hmm. I know if I've got all 8 or 10 people who are supposed to be there. So before I admit everybody, I make sure that I see who's in the waiting room. If I don't recognize somebody, as soon as I open the session, first thing I do is I have everybody identify themselves. I put names on. Sometimes it'll just have a phone number. Mm-hmm. I put a name at the bottom of that video so that everybody knows who it is. And then once you've let the participants in, you lock the meeting. Once you lock the meeting, all it does is nobody can get in. Even with the password, they're just going to end up banging their head against a wall. And you have to, because they're going to be in the waiting room and nobody will know it.
Right.
You have to then go back to the main session as the mediator and look for them. So I've had instances where people got disconnected. They had to come back in. It was a locked meeting. And so I had to see that they were gone, go back in the main session, admit them from the waiting room, and reassign them to their breakout room. But no, the security protocols have gotten much better.
Yes, I know Zoom has been working very hard on security over the last couple of months.
The Zoom bombings that you hear about are almost always like Indian Trails Water Control District in Palm Beach County had one. They put out their meeting notice, and because they're a public agency, mm-hmm. they can't lock people out. So they publish the link, and anybody can get onto the link. And once you're in a Zoom meeting, you can share screen. You can do all sorts of things that if the host hasn't protected the meeting, it can disrupt the meeting terribly. But mediations, you will always have a private link and a private password, unique password.
Perfect. Okay, we've got, I think, 2 more questions here. Do you require that insurance company representatives here, I'm sorry, hold on, this question, let me see. Do you require the insurance company representatives here live and not live? Excuse me, I was trying to figure that out. Do you require that insurance company representatives are live and not disable videos so that they can, okay. I'm sorry, Rick, I'm having trouble with your...
I understand the question. I understand the question.
Because okay, sorry.
No problem. In a lot of instances, people will come in audio only and not turn their video on. And So you see a blank screen that has usually, it might have a name or a phone number, but you can tell the person is hiding behind the video. They clicked on the stop video because they've done it before, they know. Sometimes I will ask people to turn on their videos. Quite honestly, to me, an insurance rep, a claims rep, I don't care if I can see them. I'll see them in the private session, because once they get in the breakout rooms, they always turn on their video because they want to see and talk to their attorneys. But it doesn't bother me. But if a party in a joint session requests it, I'll certainly ask, could you turn on your video? Sometimes, once, I got a response of, well, actually, I'm not in an appropriate location to turn on the video. I don't know what that meant.
Right.
I didn't want to know anymore. So,
didn't dig any deeper.
right.
Okay, great. Thank you. And Rick, I apologize. I'm very sorry that I had so much trouble with that question.
I knew what it was right away, because I get a lot of mediations where the videos are turned off. I had one, quite honestly, where I didn't raise an issue in the joint session. As soon as we got in the breakout room, I asked, because they hadn't turned their video on. I said, is there some reason you got your video off? And they didn't realize that I knew that's what they were doing. They thought that I thought they were on the phone. And it turned out that it was a very emotional trust dispute. And they didn't want to be seen by the sibling for whatever reason in the joint session. And so they had turned their video off. But in the breakout room, then they turned it back on, and I could actually see them and interact with them.
Okay. One last quick question we've got is, do you use or recommend virtual backgrounds? I know this is a big topic.
I do not.
Okay.
I basically, my office, fortunately, is set up where I can just have a backdrop of a door and a closet. But I find it distracting, because when people move quick with a virtual background, they disappear. And parts of them come back quicker than other parts. So the other reason, when you think about it, with confidentiality and Zoom mediations, is you want to make sure that you know who's in the room. And if a person has a virtual background, it's harder to tell what their environment is and whether they're in a location where there could be other people who can hear what's going on. And with confidentiality, you don't want that to be a possibility. Now, I know in some mediations, if I have a doubt, most of them I don't, but I will ask people to actually turn their computer, their camera 360 degrees, so that everybody can see and be assured that there's nobody in the room with them. So. Okay,
great. Well, thank you so much. I think that was all of our questions. I really appreciate everything. I know you gave us a lot of great information. So thank you for putting this together for us. Everyone that's still on, thank you all for attending. And also, I will go ahead and send out this, the PowerPoint or the PDF form of it to everyone that had attended. So look for that. And also, if you would like to watch this again, or you know someone that wasn't able to watch it live, we will be posting this. Like I said, it takes typically about a week or so, but we will be posting this on our website as well. So you are more than welcome to view it at that time. And if you need anything else, please don't hesitate to contact me. And if it's a direct question for Jay, I'm sure that I can probably get you in contact with him as well.
Sure.
So thank you so much. Everyone have a great rest of your day.
Okay, have a great day.
Thank you. Bye.
Bye.